Hey everyone, Harry here. So a day of enormous developments in the Supreme Court, but an important case, not of quite of the level of the Chevron overruling or of the Fisher obstruction case, but a pretty important statement from the court is the Grants Pass case. That's the homelessness ordinance case. And that homelessness has been really vexing for cities, municipalities, and it's really seems to have gotten worse. San Francisco now, many former lives are, very open to trying to do something that involves government coercion. Here's what Grants Pass did. It said, look, you can't camp on public property. That means, you can't sleep out. If you do it, we're going to give you a small fine and cite you. And that's not where the objections lie. Next, though, if you continue to stay there, we're going to get a court order saying you're not allowed to stay there. And then if you do stay there, you can be subject to a short jail sentence up to 30 days. So, all of this has a jail sentence for homelessness, right? And you can see, the huge kinds of objections that poses. Are you just putting people in jail for the status of being homeless and it's not their fault that they can't find shelter? Others, though, would say hugely complicated problem, yes, but it's not exactly accurate to say they can't find shelter. Mental illness, a huge problem in this population. I'm not a homelessness expert, but I want to, put out there that this is, a government not trying to be nasty or vindictive. It doesn't read that way, but deal with a problem that nevertheless you could say on the one hand is the fundamental right of people to sleep somewhere and not be punished because they don't have that place, as against, all the sort of discomfort of, people walking over them. But it's a very complicated issue, and certainly I think it's hard not to have some sympathy for governments trying to do basically humane regulations that nevertheless address homelessness. Anyway, that was what Grants Pass tried to do, and the Ninth Circuit said, there's a case from the Supreme Court in 1962 that basically said you can't criminalize somebody for the status of being a drug addict. And that was kind of the rhetorical or almost sociological battle beneath this, or that really infected this dispute. Is this the status of not having a place to live, or is it in conduct, even if conduct in some way involuntary? So 6 members of the court, Gorsuch writing, say this is okay, they can do this, and Robinson, the 1962 case, doesn't change it because this isn't truly status here. And Robinson is generally held for the proposition that punishing status is cruel and unusual, a violation of the Eighth Amendment. Implicitly, Gorsuch, in his opinion, gave it a kind of extra added element, which is, he said it's not like the state, and I think this is accurate, is trying to sort of, load up and punish and be vindictive, etc. And that sort of nails under the fingernail kind of idea is what he was importing into the Eighth Amendment analysis, which in Robinson was just, you can't criminalize status. And that is Sotomayor's dissent. Look, people can't find, it's just a violation of the Eighth Amendment to put people in jail because they can't find a place to live. You just got to do something, government, if they can't find a place to live. So, this strikes me as a, do they have a place to live? Why don't they have a place to live? How do they get a place to live? Does government have to say any place? Or, what about what if places are dangerous? A very, very tricky, problem. But at the core, as translated for the court, it was, is this punishing status? And, Sotomayor essentially says yes. Gorsuch essentially says no. And so now this ordinance, and maybe it'll be duplicated with its regime of slightly increasing punishment, including though, because a lot of these people couldn't pay fines. So, including a short stay in jail will now be something that municipalities can try. It seems on the one hand quite harsh and hard-hearted, but on the other, it's kind of what's a good government to do. And basically, after today, the bottom line of what the court is saying is, this isn't for us to tell you what to do, as long as you're not being gratuitous, imposing pain, being completely irrational. It's not for courts to say. You have some running room here. And Sotomayor makes the classic, this is still status. So, that's the state of play. It will have a real, effect now and change the law, perhaps in other areas as well, but definitely in, homelessness. That is a, true challenge to many, modern cities and municipalities. That's Grants Pass. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.